Welcome to this edition of HKIAC's Snapshot podcast series. Today, we will be discussing with one of Russia's leading academics and arbitration experts, Professor Anton Ososkov, the December judgment of the Russian Supreme Court in the long-running Uraltransmash and PESA case. As many listeners will know, this case relates to the amendments made in 2020 to the Russian Arbitrage Commercial Procedure Code. The code was amended to include new Articles 248.1 and 248.2, which establish in certain circumstances the exclusive jurisdiction of the Russian courts over disputes with Russian persons who are subject to foreign sanctions, including where the parties have already concluded a forum selection or arbitration agreement. The power of the Russian courts under the amendments includes the power to grant anti-suit or anti-arbitration injunctions and to recover all monetary amounts which were awarded by the foreign court or tribunal against the Russian sanctioned person. Until now, the scope of the new provisions was unclear, and lower Russian courts tended to apply these new rules only if the Russian sanctioned person could prove that its access to a foreign court or arbitral tribunal was seriously impeded because of the sanctions. However, the Supreme Court has, with its recent decision, endorsed a very wide interpretation of Articles 248.1 and 248.2, which we will discuss today. And there is perhaps no better person with whom we would wish to discuss such issues. We have with us, as I mentioned, Professor Anton Ososkov, who is a leading Russian academic and expert in international arbitration and arbitration in Russia. He is a professor at Lomonosov Moscow University. He is a member of the Scientific Advisory Council at the Russian Supreme Court, which advises on the development of judicial practice and legislative improvement, separate, of course, from the court's decision-making in cases before it. He is an experienced arbitrator, having sat in over 100 international proceedings under all major institutional rules, as well as the UNCITRAL rules. He is a member of the Chartered Institute of Arbitrators, and I'm very happy to say he is also a member of HKIAC's governing body, the HKIAC Council. Welcome, Anton.
Sarah, thanks a lot for this kind introduction, and it's my pleasure to take part in this HKIAC podcast.
Thank you, thank you. So perhaps to get us started, could you give us some background to the Uraltransmash and PESA case? And specifically, what arguments were advanced by Uraltransmash in support of the anti-arbitration injunction, and how have they been dealt with by the lower Russian courts?
Sure, with pleasure. Everything started in 2013 when an agreement, sales purchase contract for purchase of tramway cars was concluded between a Polish producer, which was called PESA, and a Russian company, Uraltransmash. What is important, I think, is that to bear in mind that the contract, which contains arbitration clause in favor of the arbitration institutes of the Stockholm Chamber of Commerce, was concluded before the date when sanctions were introduced against the Russian buyer's parent company. It was Uralvagonzavod, and Russian buyer was a subsidiary of Uralvagonzavod, against which certain sanctions were introduced by the US and the European Union. So as I've said, this contract, it contains arbitration clause in favor of arbitration with the legal seats in Stockholm, and it was governed by Polish law. In 2019, PESA, Polish seller, decided to initiate arbitration proceedings in Stockholm, claiming certain amounts from the Russian buyer. Again, what is important, arbitration proceedings were conducted for more than 2 years, and the Russian buyer actively participated in the arbitration proceedings, including by nominating its arbitrator, and also by engaging Russian and Polish counsel, quite well known and quite known legal, quite known law firms. Also, it's used a Polish accounting expert witness in order to present its position on the quantum of damages. After the amendments to the Russian arbitrage codes were introduced, and you've kindly summarized the contents of these amendments, the Russian buyer decided to make a petition to Russian commercial courts and requested to grant anti-arbitration injunction in order to block the Swedish arbitration proceedings. And also it requested the Russian courts to recover the potential amount in dispute in case the Polish claimants decided not to follow the Russian anti-arbitration injunction. So these are the most important facts of this case. And if I now move on to the decision which was taken, the issue which was in the middle of discussion actually was about conditions under which the Russian courts is prepared to grant anti-arbitration injunction and to recover the amounts which potentially which are claimed by a foreign claimant in the arbitration proceedings. And so here, two different interpretations were possible basing on the literal reading of the arbitrage procedure code. The first reading was to say that two conditions should be present in order for the Russian courts to trigger application of these new statutory provisions. These two conditions are that, firstly, the Russian counterparty is covered by the respective sanctions regime, and secondly, that the Russian party has some serious obstacles in the access to justice. This means obstacles to participating in foreign court or arbitral proceedings. And another interpretation is to say that there is a need only in one single condition, namely the first one, that the respective Russian entity is that certain sanctions apply to this Russian entity. And under this interpretation, there is no need to establish that in reality, this Russian sanction entity indeed had problems with participating in foreign proceedings. The first instance court and also cassation appeal courts decided that the first interpretation should apply. This means that two conditions should be established. And that's why the lower courts said, after finding that in reality, the Russian party didn't have problems with participating in the Swedish proceedings, it came to the conclusion that there are no grounds to apply these Russian rules and to grant the anti-arbitration injunction. So these were developments until the recent ruling of the Russian Supreme Court.
And so perhaps now would be a good time. Would you be able to summarize for us the decision of the Russian Supreme Court and how it's differed from the lower Russian court's approach?
Yeah, what is important is that quite recently, on the 9th of December this year, the ruling of the Russian Supreme Court was made public. And in this ruling, the Supreme Court clearly said that it prefers another interpretation of the Russian statutory provisions, and it prefers interpretation according to which the single condition of applying foreign sanctions to the Russian entity is sufficient in order to trigger Russian provisions about exclusive jurisdiction of Russian courts and allowing to grant anti-suit or anti-arbitration injunction. What is also important is that is the way how the Supreme Court explained its position, the reasoning which was used by the Russian Supreme Court. It said that the very facts of introducing sanctions against a Russian entity damages reputation of such an entity in the respective foreign states which introduced these sanctions. And in the eyes of the local foreign courts or arbitral tribunal with the legal seat in such a country, the Russian entity will be not on the same level as its foreign counterparty. On this basis, the Russian Supreme Court made a conclusion that the respective local foreign courts or arbitral tribunal in the respective foreign states could not be considered impartial for any disputes with participation of such Russian entity. Yeah, that's why in order to give an opportunity to fair justice, Russian courts should exercise exclusive jurisdiction over such disputes, including, as I've said, anti-suit or anti-arbitration injunctions.
And there are currently multiple types of restrictive measures and sanctions in place against Russian entities by EU member states, by the UK, by the US. And these measures are not all equal. They have differing severity in terms of how a Russian entity can interact with foreign entities, how it can transact through international banks, how it can pursue legal proceedings, and the differences of the measures is important. Did the Supreme Court define in any way the scope of what restrictive measures or sanctions would be found to be a bar to access to justice for the purposes of Articles 248.1 and 248.2?
Sarah, that's a very good question, and you are correct that sanctions can have, they are of different measure of severity and they have different legal consequences. Again, the problem is that the arbitrage procedure codes, it says in general about sanctions against Russian entities, not making clear what kind of sanctions are addressed there. And what is important in this particular case, which we are discussing, Uraltransmash case, it's important that the Russian entity, namely its parent company, Uralvagonzavod, but because of this, the subsidiary was also covered by these sanctions, according to well-known rule of 50+1% control. So this Russian entity was under severe sanctions only in the USA. So the USA decided to apply the most severe freezing sanctions against this entity. But at the same time, at the level of the European Union, there were no freezing sanctions. And in the European Union, Uraltransmash was only under much softer sanctions, namely limiting its access to the European capital markets. And what is important, still the Russian, by the way, Russian lower courts, they made emphasis on this, and they said that at the place of arbitration in Sweden, no freezing sanctions were applicable, and it was not proved by the Russian entity that the US freezing sanctions had any impact in this case. But the Russian Supreme Court, as I've said, it decided that even such softer version of European sanctions is sufficient in order to trigger the new rules of the arbitrage procedure code.
Okay, so a very wide scope and covering potentially many Russian entities, because I think the last count I saw was that the US has designated 735 persons or entities. The EU has listed 200 plus. Of course, there is overlap there, but so potentially very wide scope there.
But Sarah, perhaps I should mention that if we speak about such a softer version of sanctions, and if we look at the European Union sanctions, we will see that many Russian biggest companies are covered by such softer version of sanctions, including the biggest Russian banks such as Sberbank, VTB, Vneshekonombank, and also the biggest Russian companies from oil and gas sector, such as Rosneft, Transneft, Gazpromneft. So potentially the scope of application of legal positions of the Russian Supreme Court is very wide.
Under Russian law, does the Supreme Court's decision bind all Russian courts in future cases?
Yeah, well, formally, Russia is not a common law jurisdiction, it's a civil law jurisdiction, and formally we do not have a system of binding precedents. But having said that, I should emphasize that, in fact, decisions of the Russian Supreme Court in particular cases are very important. Of course, because the Russian Supreme Court, it's the apex Russian courts. And because of that, in practice, lower Russian courts follow legal positions which were formulated by the Russian Supreme Court. That's why I would expect that in other cases, lower Russian courts will follow the position which we are discussing today.
So what impact does this decision have on all of the existing arbitration agreements that have been entered into by Russian parties affected by sanctions, including, as you mentioned, some of the major corporations, some of the major Russian banks, major oil companies, where the seat of arbitration is in a jurisdiction that implements anti-Russian sanctions, such as the EU member states, the UK, the US. What will be the impact of this decision on all of those agreements?
I think the impact is quite far-reaching, and according to this position, any arbitration agreement in a contract with any Russian entity which is touched by this or that version of anti-Russian sanctions will be considered as unenforceable under by Russian courts if the respective courts or legal seat of arbitration is located in the country which applies the respective anti-Russian sanctions regime. And as I've mentioned, two factors should be borne in mind. First, that we've already discussed that we speak not only the most stringent freezing sanctions, but also their wider, their softer version. And secondly, that even if the respective contracts and arbitration or choice of court agreements were concluded before the dates when the sanctions were introduced, still the respective agreements will be influenced by such sanctions. I would also propose to bear in mind that, as we know, last weeks and last months, we see serious deterioration in relations between Russia and the US and the European Union. And that's why there is a real risk that there would be other rounds of anti-Russian sanctions, which may touch other Russian entities. And as I've mentioned, even if these sanctions are introduced subsequently, so after the date when the arbitration or choice of court agreements are formulated, still they have this negative influence. Having said all of this, I would recommend to all counsel and advisors to think, to get acquainted with this Russian court decision and to reconsider all arbitration and choice of court agreements in the contracts with Russian counterparties, and to think that maybe it would be a good idea to start negotiations in order to change the respective provisions, and thinking about alternatives, so how to avoid this legal risk of recognizing arbitration agreements unenforceable under Russian law. I would say that it's important to think about those leading arbitration institutes which are located in countries which do not participate in anti-Russian sanctions regime. And of course, from this perspective, I think HKIC is a very good option because Hong Kong and mainland China, they do not participate in this anti-Russian sanctions regime.
Wonderful. Thank you very much, Anton, for your insights and your views on this very important Supreme Court decision. And I'm sure that there will be much discussion about this going forward. So thank you very much for having this discussion with us today.
Thank you, Sarah. It was my pleasure. Thank you very much.
Thank you.